So this is for the technical, the housekeeping side. Let me now also switch the hat and just welcome you again as director of the Geneva Human Rights Platform. We're delighted to partner with UN Habitat, Geneva Cities Hub, GLTN, and the Housing and Land Rights Network in this debate with Michael Vintfore, the rapporteur of the Committee on Economic, Social and Cultural Rights, co-drafter of this text jointly with his colleague and the advisory board member of the Geneva Human Rights Platform, Rodrigo Primni, who was not able to join us today, and also based on the work of a former colleague at CESC at the Committee on Economic, Social and Cultural Rights, Olivier de Schutter. At the Geneva Human Rights Platform, our mission is to support the Geneva-based UN human rights mechanisms in their functioning and to link them with a wider audience. So what we're doing today fits actually perfectly into our mandate, into what we are doing. It is very important, I think, to involve many stakeholders in the processes around the UN treaty bodies, as a process now in the elaboration of a general comment, as those stakeholders are since decades actually engaging in those very issues, just maybe from another angle. And this is also what we'll be exploring today, getting discussion, getting input with people who are working on land, on access to land, on land rights in various functions. So it is my pleasure now to hand over the floor also for opening remarks to Robert Louis Lettington, first of all, of UN Habitat. Robert is the Chief of Section of the Land, Housing and Shelter and Urban Practices branch at the Global Solutions Division, but he's also coordinating the Global Land Tool Network. So Robert, over to you.
Thank you very much, Felix. It's a great pleasure to be able to address you today. And first of all, I would like to very much thank all of the partners around this meeting. First and foremost, the Geneva Human Rights Platform and the Geneva Academy, who've provided the technology and the venue for us to be here and made it happen at very short notice. Also Camileva of the Geneva Cities Hub, and Joe, who is online from Habitat International Coalition. Our aim in pushing for this event today is to increase awareness about the general comment, to encourage discussion. We are not particularly trying to push for positions or content in the text. We believe that at this stage, the broader the engagement that is possible, the better. We have a comment period running up to late July. We hope that this event will create space for people to think about what the general comment means, to reflect on its content a little bit more, with a little bit more access to information, and then to take that forward in the way that they see best. We also hope that we will join you all in several more discussions as we go through this. From Habitat's own point of view, before I just make a couple of observations on the content side, I would also congratulate the committee of experts and Michael and Rodrigo in particular, the principal authors for this initiative. Without any question, this has the full support of UN Habitat, and we see it as a very important step to addressing several challenges in land governance at the global level. First, we are concerned that currently there are no effective frameworks or forums for considering land and development in its full scope. There are some forums with a narrower agenda and a narrower set of priorities. For example, rural development is quite widely discussed within forums at FAO. There are some economic forums which take up land issues, but there is no opportunity to really look at land in a broader and more integrated fashion. We believe that taking a human rights-based approach to land governance may provide that opportunity in that forum that we have been looking for. We also find that discussions regarding land governance and land management are often driven by very utilitarian factors. There is a heavy focus on production, economic value, economic role, and other similar influences like that. Yes, these are important, and they will always be so, but they need to be balanced with a number of other social and cultural characteristics. Not just because that is the right thing to do and a question of rights, but also because it is in state interest to do that. Good land governance contributes to stability, it contributes to good governance. And that is a major issue that we are encountering in a number of conflict and fragile state situations at present. We would also note that the existing guidelines which are available, while very good, such as the voluntary guidelines on tenure that were developed within the scope of FAO, and the targets for the Sustainable Development Goals, while these are very useful, they either tend to be somehow limited in geographical scope. For example, the VGGTs are very focused on rural development, or they're too limited in nature, for example, the SDG goals and indicators, to fully support policy making at the national level. The current situation provides us with an opportunity to take a more holistic approach to land policy. I would also note that we are generally observing amongst a lot of member states that there is an absence of active land management. There is a tendency to rely on the market to determine a lot of land outcomes. There may be some public activity in terms of land banking, some elements in terms of easements and regulation of land use, but these tend to be limited, and the principal tool tends to be market allocation. We believe that there is a case to be made for substantially more active land management, particularly where large proportions of urban populations are excluded from access to land for shelter and economic purposes. We are glad to see that these issues are referred to in the draft general comment, but we also believe that there may be more scope to elaborate on those further. I would particularly like to note that the approach of using the respect, protect and fulfill framework is one that we strongly appreciate and endorse. We believe that this will lead to a much greater consideration of the day-to-day issues in land management that determine outcomes. How do governments, not just at the national level, but very frequently regional and city governments, who are the ones who have to make land decisions and are responsible for the associated outcomes, how they do that and how they can intervene in the land market is extremely important. We believe that a human rights-based approach provides a very good foundation for this, and through the respect, protect and fulfill concepts, that is something that can be delivered. My final point is just to note that we believe that also while it's noted in the general comment, we may need to look further at the issue of urban land. Urban land, I know there is not a straight dichotomy between urban and rural. There is probably more of a continuum, but in many urban areas, there are different issues related to value, use, access, contributions to public health and public utility, and the relationship between land and communities than one might find in lower density areas. And these are things that plug very directly into economic frameworks of states and need to be looked at very carefully in the development of national policy. Again, we believe this general comment provides a very good starting point for building up and encouraging good policy in these areas. So with those few remarks, and looking forward to everybody's comments and a great discussion. Thank you.
Thank you very much, Robert, for those introductory remarks. And indeed, you touched already about also the urban aspects. And as I mentioned, we're a diverse group of organizers. So it's my pleasure to give the floor now for her welcome and introductory remarks to Camelia Kamileva, who is the co-director of the Geneva Cities Hub, additionally to being a former colleague here at the Geneva Academy. Camelia, over to you.
Thank you, Felix, and thank you, colleagues. I feel quite at home because I also used to work with Felix on human rights issues, which makes me familiar to this topic. And I wish also to congratulate the Committee on Economic, Social and Cultural Rights to go that direction. I think it's very needed, and more I deal with urban issues, with affordable housing in cities environment, more, I believe that this general comment is a very needed tool for this reflection. So I represent the Geneva Cities Hub, which is a Geneva-based initiative created by the federal government of Switzerland, but also by the regional and the local government of Geneva. So the sort of the three layers which in Switzerland and elsewhere are dealing with land, land property, land tendency, etc. And the Geneva Cities Hub supports cities and city networks to contribute more effectively to multilateral processes and bodies. And we also provide a platform for neutral platform for discussions, meaning that we are not only specialized in human rights, but we deal with all the topics which are relevant for cities. In the concrete general comments, and I'm not a very big expert, so Michael, I will not sound provocative. I want to sound constructive to you and probably trigger some comments from you right when you present the general comment or after. But I didn't find any reference to cities and moreover, any reference to local and regional governments. While it is understandable that the approach is towards states, because at the end of the day, states are those who ratify the treaty and benefit for general comments. My understanding, and I'm sure you share it entirely, the general comment goes beyond the states ratifying, obviously, the treaty. It goes also to states, to other states and other stakeholders. And for us, for the Geneva Cities Hub, without any doubt, local and regional governments who usually have a word to say for lands, they have a word to say in land governance and tenure, are the potential addressee and subject of this general comment. So probably there is a reason that they are not mentioned, but I would like to hear this from you in the presentation. And also probably to mention that it will be good to make the link. I think Robert just said it a little bit more precisely than me, but the link from land to affordable housing and all the chain of rights and problems which come when we talk about lands and land property and economic, social and cultural rights. These are just welcoming remarks. I will stop here, and I'm very much looking forward for the debate, and thank you all. Thank you also the audience for being with us.
Thank you very much, Camelia. Thank you for those comments from the urban perspective and the questions already up front to Michael. Let me turn to a further co-organizer of this meeting, to Joseph Teschler. He is coordinator of the Housing and Land Rights Network, Habitat International Coalition. He's joining us from Cairo, and I understand that the connection does not allow for camera use, but I hope we'll be able to hear him perfectly. So Joseph, over to you.
Okay, thank you very much. I hope you can. I've already had some breaks in the connection, but I hope everything goes well. First of all, I want to extend a tremendous debt of thanks to the drafters of this document. This is very much welcome, long anticipated. In fact, some of us have been anticipating this for at least 15 years, seeing the importance of land as an element, perhaps the first element in a chain of elements needed to realize economic, social, and cultural rights. We appreciate very much the challenge that the drafters face in this, especially with the new composition of the Committee on Economic, Social, and Cultural Rights. I also appreciate very much the holistic approach, the challenge of that, distinct from other instruments, as Robert mentioned, that are custom designed for specific uses in a geographical or a demographic scope. But this is dealing with land as as an element, as a subject that crosses all borders, and in fact aligns much more with the original habitat concept, that is an approach that requires consideration of human settlements, whether they're villages or cities, as points on a human settlements continuum within a common ecosystem. That's taken from Habitat 2, paragraph 104, for those who want to look it up. But we also have a tremendous challenge to deal with the question of indigenous peoples, which is dealt with quite well in this document. But something that's missing in a lot of the literature is transforming our understanding of land, and especially the organic nature of the relationship between indigenous and other land-based peoples and land, but especially indigenous peoples, beyond just a kind of an exotic, earthy, colorful, and poetic expression about the relationship to land, but beyond romanticizing that relationship, we can also understand why land is so sacred for all of us, when we understand also the geophysics, the health links to land, for biological reasons, for gravitational biology reasons, for electromagnetic reasons, but the body cannot exist without land. And therefore, it is really a subject for all of us, not just a particular people. And to have that change of mind or change of heart, this is kind of the anticipation that we have for this dialogue, this process, if not also for the general comment itself. What's really important too in this is the address, how the committee has addressed the overriding principles of non-discrimination and gender equality. I would suggest also that in the specific discussion of land, the other overriding principles are just as important. That is, there are 7 overriding principles in the covenant, and that methodology of the covenant helps inform us how we deal with land, at least in our coalition in the Housing and Land Rights Network. Not least of these is Article 1 of the covenant and its guarantee of self-determination and land, and the prohibition against the denial of denying a people of its means of subsistence. Land is also one of the essential criteria for the state itself. The issues of permanent sovereignty over natural resources and the norms that apply in that case. And of course, peoples under occupation and alien domination are particularly timely. Well, unfortunately, we're still living in a period of colonization of land. And notably, while the SDGs are also important in these last 10 years of the Agenda 2030, this year we also enter the 4th international decade for the eradication of colonialism. So in that frame, or in that shadow, we're seeing that the question of rights to land are inextricably linked to, I said rights to land, which of course the general comment avoids. It says that in paragraph 8, the covenant does not affirm a self-standing right to land, although a number of its provisions are relevant to the governance of land tenure. Then it turns to the question of women who have a right to land in paragraph 16, but we tend to be beyond sort of, or before we evolve beyond the usual discourse on land, where we seem to be still stuck in the important dimension of tenure. So the committee is really walking a tightrope, attempting to deal with tenure and the diversity of tenure types within a single governance system without calling it property, which is not affirmed in the covenant. We don't have a human right to property recognized in the covenant. So therein lies a very interesting dilemma for all of us. And also, I just wanted to point out the really vital importance of the extraterritorial obligations of states as it's dealt with in this general comment. It recognizes, although maybe not explicitly, that the state has obligations individually, collectively, domestically, and extraterritorially, but explicitly in the question of extraterritorial obligations. That's really constructive. What's also, I think, important because of the methodology of the covenant and also the question
Joseph, there's a technical problem. We do not hear you, Joseph. So actually,
of state claims under international law,
Joseph, we did not hear you. So actually, I think we'll move to the presentation of Michael, and then we'll call on you again to comment, also to continue in the comments on the draft. So Joseph, if this is okay with you, because unfortunately we lost the connection. So let me turn to Michael Vintfore. It's a little bit a sudden switch now, but we'll come back to Joseph actually, because I think he also already started really commenting on very specific areas of the draft that you're going to present. So I think Joseph will be able, hopefully technically, also to join us again and comment then also again in light of what you will have presented. So let me just present you. Michael Vintfore is a member of the Committee on Economic, Social and Cultural Rights, where he is the rapporteur for this general comment on land and ESCR. He is also, in the little free time that the committee leaves for him, he is in his day job co-director of the German Institute for Human Rights, which is the German National Human Rights Institution. Earlier on, we knew Michael also from leading positions in NGOs, including Secretary General of FIAN International and Human Rights Director of at Bread for the World. So also in the NGO world, Michael has worked a lot on this topic. Michael, turning to you, could you provide us, first of all, obviously with an overview of the draft general comment? But then also, I think the general comment looks first into the meaning of land and the realization of covenant rights, then into the state obligations in general and obligations relating to land. So I would like to hear a little bit also on specific points, for example, as they were raised already by Robert or by Joseph, how that general comment fits land into the respect, protect and fulfill framework. Also, what you'd like to say about extraterritorial obligations. And then I think also what is interesting is that in the latest part, in the final part of this general comment, the draft general comment, you look into specific topics such as conflict and post-conflict settings, peasant rights, that also my colleague Christophe Goulet will address later on in this meeting today, but also climate change. Would you like to maybe highlight already in your presentation some of those and also say why altogether you go into such specific settings with that draft text and in which settings you might not go? I think there was the question of camellia of the cities and local government. And yes, obviously then also where you'd like to really solicit most input from this specific network and the people of the network that we have assembled and gathered today in this meeting. So Michael, the floor is yours, and we're very much looking forward to hearing about this draft text, which you already received with lots of thanks and congratulations, and I'm joining mine to this as well. Over to you, to Berlin.
Yeah, thanks a lot, Felix. And thanks for giving me the possibility to present the general comment, the draft general comment to you, and also to receive feedback. My main intention is, in a way, to listen to comments today, because that's very helpful for the committee. It's a good opportunity for the committee to learn And we deliberately has looked for a period of 3 months to invite everybody, every stakeholder to comment on the general comment, because land is a complex issue. We know this, and we have 10,700 words. So it's the combination of the two things, very complex and at the same time very limited frame, which makes it complicated and difficult to please maybe everybody, or takes all issues in appropriate way. So for us, it's also good to hear where we might, in the further process of developing this general comment, do some rectifications, changes, whatever might be needed. The idea is that after the 3 months period, which is extended up to the end of July, we are going to rework the draft for our autumn session, and if possible to adopt it either there or in the spring session next year. You have to keep in mind that a general comment is not the work of just 1 or 2 or 3 rapporteurs. It's at the end, let's say, an adoption in consensus of the whole committee. So also the rapporteurs have to take on board all positions in the committee itself. I think that is one of the obligations which we have, otherwise we can't adopt these general comments. And this is also maybe the reason why they are not uninteresting texts and quite influential in many aspects. So land is for the committee an issue which has been important from the beginning. We have already had a general comment on forced evictions in the 90s. We have written text on agrarian reform. We have in the general comments on the right to food or the right to water, we have elements which are strongly linked also to land, the use of land. Access is an important precondition for the realization of many of the covenant rights. That's what we have also written at the beginning of the general comment. So particularly for all the rights related to the adequate standard of living or the livelihood rights, food, water, housing, but also for the right to health, but also for many other aspects which has been already mentioned by the 3 speakers in the beginning, or who already were mentioning several of them, like protection against non-discrimination and others. So therefore, we have chosen to say this is a general comment about land and economic, social, and cultural rights, because land is a component which is important for the realization of many of the covenant rights. It's not just a right, it's a component for many of the rights in the covenant. I think that is the process chosen and where we had a consensus in the committee. We already are referring that we have a lot of processes nationally and internationally which are changing the use of land, the access to land as a resource for housing, but also for productive assets. This can be processes like environmental degradation, climate change, urbanization, land grabbing, financialization of land markets in rural areas and urban areas. So there's a strong, in a way, call in many areas for a better governance of land in government settings. And I would deliberately say at all levels, national governments, but also local governments. So this is meant when we talk about governance of this. So we need to have a good land governance system. And this is also at the core of it. We describe how that could be looked like. The text is also written from the perspective that access to tenure, it was already said, is at the core. We don't talk about property rights. We talk particularly about the access of vulnerable groups or marginalized groups. That can be pastoralists, it can be indigenous peoples, it can be urban squatters, to land in a way to use it for the different purposes I have already described. And this is at the core of the, let's say, endeavor which we have started. We use a term which has been used or developed in the context of the voluntary guidelines on governance or responsible governance of tenure of land, forests and fisheries, the legitimate user rights, which doesn't ask for the legitimacy of the user. It talks about that we have so many users which have no documented user rights. In some parts of Africa, we were reading in the process of developing 90% of the, let's say, user structures are informal or non-documented. So that is a reality which we have in many areas. And to talk about this is at the core. Yeah? Security in access to tenure is therefore one of the key elements. We also want to say that land is much more than a productive resource. And Robert has already mentioned this. It's a fundamental component of ecosystems. So the environmental functions are extremely important, biodiversity, climate change. This is extremely important. And if we don't see this holistically, also the use of land, that it needs to be sustainable, because otherwise it might change dramatically how land can be used also in future. But we talk also about the cultural importance of land. And this is relevant, particularly for indigenous peoples, but we have also so many other customary forms of using land that it is not just indigenous peoples, but many other land users who have an extremely cultural importance for their own existence, being, but also economic living, which is needed. And we talk about conflicts over land use, changing of land transfers, evictions, all these processes which are happening on the day-to-day basis, because if we don't talk about those processes who might endanger existing access, maybe even undocumented, not written access people might have to land, we are missing what is maybe at the core, which is security of access in the long term. So this is just to give you an idea where we have started from, embarked from, what we have tried to incorporate. And there might be things which needs particularly attention, or maybe a different attention. Therefore, we are willing to listen to anything, and we hope to get a lot of good proposals. Keep in mind that the text is already 300 words too long. So if you make a proposal, you might also think about what to delete. And this is maybe the most restrictive way of thinking about such a text. Let me dive into the text, and I will try to do it quite briefly, not extending my 20 minutes, which I have, just to give you an indication, and you might have read the text already. So it just describes you the way we have now addressed it. And then we can dive into the discussion, and I might answer more specific aspects when we are discussing later. We start by saying what are, in a way, the priority or the areas, let's say, provisions in the covenant related to land, which we already have. I already expressed this, what we have on housing, food, water, in cultural life. So we describe what is already in the covenant, which can be used or which is related to land. And we also dive a bit into what we are already doing when we are examining state reports. We often, very regularly, come to land issues, ask for land conflicts or related issues. So we have a certain history of dealing with land issues, and that's what is reflected in this part 2. We then go into what has been called by Robert as a good part, the discussion of state obligations. And in this, we, like in other general comments, we first take up some more general aspects of state obligation. We talk about non-discrimination and equality under A. We talk about participation, consultation, and transparency, the human rights principles under B. And then we go into the specific obligations states parties have under the covenant with aspects are related to land. Yeah, and under non-discrimination and equality, we have two groups particularly in mind. First, that are those who have a, let's say, often a communal access to land because they are very poorly recognized and safeguarded in land registration system. This is indigenous people, it's pastoralist, many other customary forms of access to land. But also we are highlighting the issue of landlessness because this is a big issue in many states in the world. So these are one of the groups we are mentioning. And the second group we are mentioning particularly is women's access problems to land. And this goes through all, let's say, elements in which women are related to land as users, as inheritors, and as rights which they have in couples and so forth. So these are the two groups which are particularly highlighted there. And then under B, we briefly mention the importance of participation, consultation, and transparency. We know that for indigenous peoples, we have these principles of free, prior, and informed consent. The voluntary guideline is also mentioning the extensive participation clause when it comes to land and land use structure for all others. We just want to highlight at this level that to all forms of policies related to land registration, land administration, land transfer, land uses. These elements are extremely important, because if you have no transparency, who is owning or who is using land, if you have not a consultation when land use change is happening, and if you don't participate people, all the processes might lead to human rights violation, might oversee people and groups. And therefore it is so essential that these principles, these human rights principles, are respected. Then in the part of obligation, we follow the logic respect, protect, fulfill, which the committee has used since 1999, when the General Comment on the Right to Food was adopted, and has been consistently used by all the other general comments since then. Respect describes what the state has as an own obligation vis-à-vis its citizen or the people living in the country related to land. Protect means where the state has to regulate third parties, that they don't interfere with the access from citizens or people living on the land to productive resources. And the fulfill dimension is what has the state to do in order to guarantee that also those who currently have no access to land, which is a big group in many countries, can get it better. How the state can make sure that it uses, as the covenants say, the maximum of available resources to create a fair and good access to productive resources, to the maximum of the resources available. And we have now, under the respect, protect, fulfill, described in several paragraphs always what we think is relevant for these obligations. Under respect, for example, is recognizing existing access to land use and not to land ownership. That is important. Guaranteeing security of tenure, non-discrimination in access, indigenous people's rights, talking about tenure security, about how to deal with evictions, forced evictions. We determine that it can be only done or should be only done for public purposes, that if you just distribute land without supporting those who are receiving land, you might lead to a commodification of land. We talk about all the regulation which is needed for informal tenure, informal uses of land. So we take this sensitivity, particularly to groups often overseen, not registered in existing land cadastre systems. And the text is then also asking for a good system of, let's say, protection and security in land register and land administration for all these groups, to make sure that this fits together in protecting long-term security of access. This is also requiring, let's say, a good regional planning and spatial planning. It's under the obligation to fulfill, where they're saying this. If you're not documenting which type of land is used by whom, or what type of land use structures you have, your patterns you have, your spatial planning, then if processes happens like large-scale acquisition of land, or maybe even climate change, which might force certain groups to move because the land is no longer usable, or it's flooded or becoming desert, then you need to have an understanding what are the circumstances under which people are using. You can't just bring them to other plots where might be other people undocumentedly using land since decades or generations. So this needs to be combined, administration and also the planning, regional and spatial planning, in a human rights-based manner. That is what we are explaining. The obligation to protect then describes everything the state has to do in regulating third parties. That would be, for example, private investments, international investments coming in. It describes what type of safeguards needs to be on place when people are buying or land transfer processes are started. We talk about what type of regulation of business entities is needed by states in order also to make sure that large or any forms of acquisitions are done in a human rights-based way. And we particularly warn against any type of formalization or financialization of markets. If you don't regulate it properly, it can lead to an extreme concentration of land. Then we, under the fulfillment, we particularly discuss the issue of creating access to land for those who don't have access yet. We talk about land reform, agrarian reform, also of the colonial aspect Joseph was already mentioning. We refer to the ICAT conference from 2006, and we say, as the voluntary guidelines on the right to food and also the general comment number 12 is saying, what does it mean if states use the maximum of available resources when it comes also to land? This is an important component, and it is explained there. This is set all on the national perspective, but we then also have a chapter discussing the extraterritorial dimension of state obligations. And again, we follow the 3 levels: protect, fulfill, respect, protect, fulfill, and we explain the different layers. Yeah, so we first say states have also an extraterritorial obligation to respect. So they should make sure that their own policies abroad don't interfere with the safe security of tenure. For example, development policies, for example, state sovereign wealth funds buying land in other countries, and all this are extremely important. So we are talking about where states we are asking for coherency when they support energy projects, agricultural projects abroad, or where maybe its own agricultural policies or energy policies are affecting access of people to land abroad. This is all taken into consideration. Under the obligation to protect, we talk about that states, in the line of our general comment number 24 on business and human rights, must regulate private actors, transnational corporations that do not impair the enjoyment of covenant rights of people in other states, so that they make sure that through own investments, or maybe also through actions through the whole supply chain, mining activities and others, they don't interfere with these safe security of tenure. And we then also talk about the obligation to fulfill. States often do in international cooperation and assistance a lot in a way supporting the recognition of land. They have a lot of policy advice, how to make establish land cadastre system, tenure, registering of tenure of land. And we say states, when doing this, needs to keep on board their human rights obligations, having the adequate safeguards on board, installing complaint mechanisms that these projects and these supports are really human rights based and do not lead to negative consequences. To come to an end, we have then a 4th chapter which singles out certain specific topics relevant for the implementation of covenant rights in land-related contexts. And well, we have 6 areas identified which we are specifically talking about. One might say, why we haven't talked about urban land, which we have tried to cover when we talk about the different obligations, because it's not something which is just a specific thing, but we have at least 6 things mentioned. One part is dealing with armed conflicts and post-conflict situation, because it's extremely important how you deal with these conflictive situations. We have a lot of protected conflicts where land has been maybe given to new landowners, and then 30 years later you have to look for solutions between the original user, the later user. This is at the core of protracted conflicts, also armed conflicts, civil wars. So that needs to be solved systematically. We talk about assessment and monitoring measures, because very often states are not having enough knowledge about land use structures. And if you are not sensitive, you might oversee land uses, and you might create really substantive problems. So this is a particularly problem. The 3rd element is that we talk about corruption, because this is a larger problem in all land-related, let's say, arrangements, policies, a substantive problem. We have then, as a 4th element, taken up the issue of peasant rights, and I know Christophe Collet will comment on this also, where we have at least said that while the general comment talks about land and economic, social, cultural rights, not from starting from a specific recognition that land is a human rights, we call in this section particularly quoting the UNDROP declaration that for groups like peasants, land might be functionally equivalent to a right to land. So we go quite far in supporting what has been described in the UNDROP declaration, and we quote also the respective article of UNDROP in this aspect. Then we talk about human rights defenders, because this is a particular issue. If you follow the latest reports of the special rapporteurs on human rights defenders, the old one, Michel Forst, and the new one, you will easily, Mary Lawler, you will easily see that human rights defenders land human rights defenders are often at the core of so many conflicts. Also, environmental human rights defenders are often those who are defending land, access to land, and sustainable use of land resources. So this is one of the groups of human rights defenders which are most at risk. So we have put an emphasis on this. And then at the last point, we speak about climate change and mention both the need for states to mitigate their own impact in creating climate change, but that also the way how you deal with the adaptation to the change on land use patterns through to climate change is so essential for large groups of populations worldwide, that this needs to be particularly mentioned. These are the 6 single issues or topics we have spelled out. And then at the end, we talk about remedies, and particularly we do a duplication in this. First, we talk about land remedies in all the institutions dealing with land, because that is particularly important, that if you are somebody whose land use structures or your tenure is secured, it needs to be clear that this is available. And then we talk about the judicial authorities. They should be available. You should have legal aid, even in remote settings. You should have access to court procedures looking into this land rights issue. So all this is basically the structure and the content of it. I couldn't go into all the details, but I wanted to give an overview how we have tackled the issue so far. And we are very open for any comments. Keep in mind that the restrictions we have in the size is really a limiting factor. So you have to put emphasis on certain things, but we are open to any further comment. And therefore we are glad that we took the time this time for a 3-month period for comments. The draft is at the moment available in English, but soon be also available in French and Spanish. And you can also send in your comments in these 3 languages, that it will help us in order to dive into all the comments later and then improve our draft. And don't forget, it goes then back to the committee, and we need a consent by all committee members to that text at the end. So that's my presentation, and it's 21 minutes. Felix, I hope it's okay.
Thank you so much, Michael. And yes, the additional minute was for the additional 300 words that your document currently goes over, so it's perfectly okay. Thank you so much for that outline, and actually already quite substantively going into the different parts. And as you say, we are here to have comments. And so we have a number of comments that we ask people to prepare. And as I said, we will have really an open discussion to give input, to give feedback to your presentation and to the text. And I see also that the chat is already starting. We have a first feedback and comment also, and we'll pick up on that also later in the discussion. Let me now hand over to Camelia, who will continue the moderation of this next section of the discussion, placing the draft in the wider human rights framework. With this, over to you, Camelia.
Thank you very much, Felix, and thank you for having this opportunity. In order to go also directly in a more interactive setting, I wish to give the floor obviously to Christophe Gollet, who is our colleague, actually Felix colleague here at the Academy. I think it's not exaggerated to say one of the biggest experts on the peasants' rights and the peasants' declaration, which was relatively recently adopted at the Human Rights Council. And then probably, Joseph, if you are back and your connection is good, to give you the chance to finish your presentation. Also within this section about, for example, the links to the UN Declaration and text-back mechanism on the rights of indigenous peoples, as well as then quite quickly open the discussion about links with the other UN human rights system in large. I would not be against also to mention broader links and how this can be brought up to the Human Rights Council, although I know that there are some probably how can I say some feelings which are that the general comment should be separated for the political forum, which is the Human Rights Council. But I wonder whether we can escape from any connections. But again, let's come back to Christophe. So Christophe, it's not a competition, but the indigenous people are tackled in the core of the general comment, like the peasant rights are the number D of the last page. So do you feel this is correct and right? While, however, the land is the central piece of one of the central pieces in the Declaration of the Rights of Peasants. And would you suggest probably to increase or sharpen the text, or even put it in the main part of the general comment, or not? You're the expert. You have the floor.
Thank you very much, Camelia. Thank you very much to the organizers for the invitation. I'm very happy to be with you, Michael, to comment this general comment. Thanks also, of course, to Rodrigo and Olivier, who are not there for the work on the general comment. Yes, as you say, it's a good introduction, Camelia. I have, as you know, I have supported the elaboration of the Declaration on the Rights of Peasants between 2012 and 2018, giving advice to the chair of the negotiation, to states, NGOs, and social movements, including La Via Campesina. And so in commenting this general comment from a job perspective, yes, it is true that I have mixed feelings. First, I'm very happy to see that many key elements of UNDROP are included, and that's, I mean, of course, it should be welcomed, and yeah, it's really great. But yes, I must admit that I'm concerned about the treatment of UNDROP and of the rights of peasants in this draft. And so in my comments, I will concentrate on what can be improved. Okay, I will not concentrate on all the good things that you did in including the rights of peasants in the general comment, the draft. But I will concentrate on what can be improved. So, UNDROP has been adopted after 20 years of mobilization by La Via Campesina and its allies. It covers the rights of peasants, landless people, rural workers, herders, pastoralists, fisherfolk, and their families, who represent 2 billion people. Okay, they are particularly vulnerable. These people, they represent 70% of those who are live in extreme poverty, and 80% of the world's hungry. And if I quote UNDROP's Article 1, they have a special dependency on and attachment to the land. So it's very true that the right to land, access to land, is really central in the whole declaration. And they are among the first victims of human rights violations associated with land, and therefore among those that the committee aims to protect through this general comment on land. So I think that they should therefore be explicitly mentioned each time the committee refers to vulnerable groups in the general comment. And so each time you talk about vulnerable groups, you should, I think, refer to the peasants and other people working in rural areas. It's not the case in the draft. I think it's also important that the committee does not only refer to UNDROP a few times, now it's only once in the text and twice in the footnotes, or summarize it in a very small paragraph. You said it's at the end, Camelia, on paragraph 52. I think instead you should try to include UNDROP in a systematic manner in all relevant parts of the general comment. I try to understand why you don't do it, and why it's not in the same level as the UN Declaration on the Rights of Indigenous Peoples, and so maybe it's because UNDROP has not been adopted by unanimity, but I would just give a few information on that. It's been UNDROP has been adopted by a large majority of the states at the UN General Assembly after 6 intensive years of negotiations, during which every word has been well chosen by negotiators. Most of UNDROP is based on agreed language, and negotiators have cut many elements that they considered problematic, including wording taken from the declarations on the rights of indigenous peoples that we had proposed in first drafts, such as the right to permanent sovereignty over natural resources, the right to territory, and the right to free, prior, and informed consent. So all these rights, they were included in the drafts declaration, but they were not accepted by the states, and so by negotiators, and so there was a compromise and there were cuts. And so what we have in Articles 5 and 17 on the right to land, so the right to land is not only Article 17, but also Article 5. It's what we have in these two articles really is what has been accepted by states. And if we want to explain why some states opposed to the declaration when it was adopted or abstained, I think it's more important to understand their reserves towards the right to seeds than their position on the right to land. I think the right to land has been a lot more accepted by states during the negotiation and by negotiators than the right to seeds, even if we have at the end the two in the declaration. But there is no there is not a lot of opposition to the right to land in this declaration. I'll just take one example of the work of the committee in the last 20 years. And I was there when the committee elaborated the general comment on the right to water in 2002. And at that time, many states were against this recognition. And you remember that many states, Canada, UK, were the first ones, said that the commission should not have done that. But the committee, by recognizing the right to water in general comment, a whole general comment on the right to water, promoting this right, which is now recognized by all states. So I think that it's now time for the committee to promote UNDROP and the rights of peasants through this, including through this general comment. Just want to highlight that in 2019, the UN Human Rights Committee referred to UNDROP to protect the right to land for the first time in the individual case. The Inter-American Court on Human Rights did the same in 2020. In 2019, 9 UN special procedures and 4 members of UN treaty bodies, including member of the Committee on ESC Rights, Olivier de Scoter, committed to protect the rights enshrined in UNDROP, to integrate UNDROP in their mandate, and to provide guidance to states on how they can implement UNDROP. It was done in a joint statement on the 17th of December 2019 for the 2 years anniversary of the declaration. There was a joint statement of UN treaty bodies and special procedures issued at that occasion. So I think that in this general comment, the committee should clearly say that UNDROP enshrines the right to land, like it does say it for the right of indigenous peoples in paragraph 26. It's difficult to see why there would be a difference in the treatment of the two declarations. And I agree with Camelia's question that there should be a paragraph 26b or something like explaining that the right to land has been recognized in UNDROP for peasants and other people working in rural areas. I think there is also a need for the committee to refer to UNDROP in many parts of the general comment, including in relation to non-discrimination, rural women's rights, protection against forced eviction, displacement, and land exploitation, entitlements to agrarian reform, conservation and sustainable use of land, consultation, participation, and transparency, access to justice and remedies. It's all topics that are in the general comments and for which there are very many articles of the declaration that are relevant. And in many of these parts, the committee in the general comments refers in footnotes to a decision of a regional human rights body or to one author in the literature, while referring to UNDROP, I think, would be more convincing. So to conclude, again, I have concentrated on what can be improved, but I could have also take a lot of time on what has been done that is fantastic and brings a lot of things to protect the rights of peasants. I hope that with organizations that fought for UNDROP's elaboration, adoption, and now implementation, including La Via Campesina, we can provide the committee with useful written comments to support the inclusion of UNDROP in this general comment. I thank you very much for your attention.
Thank you very much, Christophe. And just to mention that we didn't even consult it in advance. This was a spontaneous comment of a non-expert. So thank you. I think it was important. And I think probably also this can be put forward in a more formatted way as a comment to the general comment. Before opening for discussion, and also I'm very keen to hear from participants, the link with other UN human rights treaties and treaty body system. You made, Christophe, the link with another general comment of the same committee, the general comment on water. But previously we spoke about non-discrimination and women's rights. And I'll be very happy. Probably we will not have time in this meeting, or we are not specifically prepared for this, but to really speak about these topics. Right now, as I see one of the other colleagues we have here, she's gender expert, and probably this actually comes together with my question. I will give the floor to Joanna, but also please, Clarissa or Joseph, as I said, raise your hand if you want to speak, and I'm happy to revert to you before we go into the general discussion. Joanna, tell me, it's on gender and women's rights.
You know me so well, Camelia. Thank you. Thanks very much for the introduction. And I think it's a great initiative to have this general comment. I'm particularly interested in the section on discrimination against women and women's land rights. And I just had a quick reflection because I see that you have referred in paragraph 16 of the draft to one of the earlier CEDAW general recommendations. But I'm just wondering why there's no reference to CEDAW General Recommendation number 34 on the rights of rural women, which does actually contain a lot of, I think, important discussion from the perspective of CEDAW about questions of land rights and land inheritance and non-discrimination. So that would be one suggestion from my side, would be to have a look at CEDAW General Recommendation number 34. And the other thing would be perhaps to refer to the FAO voluntary guidelines on governance of tenure, which also has a lot of different provisions that refer to gender equality in land rights. So that's just my reflections there. I did also have a few other remarks, but maybe I can send them in writing, related to some of the reflections around the non-economic values of land. And I think that it would be really important to perhaps go beyond the existing ways in which these are framed in human rights discourse and look at some of those ontologies of land that we see in customary tenure systems, in indigenous tenure systems, that do emphasize that relationship between humans and nature in ways that are not extractive, in ways that are more sustainable potentially. So I think it would be nice if there could be some greater reflection around some of those issues. And finally, in paragraph 15, where you're talking about the commons and titling or formalization of communal land, there, I think it would be really useful to refer to some of the initiatives and some of the literature out there about ways in which this can be done creatively, because at the moment, there seems to be this presumption that formalization of communal land tenure as it exists will automatically lead to inequalities and distortions. But I think that there may be scope for having a more positive spin on the way in which this could be done more sensitively to recognize communal land tenure. Thank you.
Thank you. Thank you very much, Joanna, for stepping into this. That was great that you replied to this general comment about connections with UN Human Rights Treaty body system in general. As I said, getting back to Joseph, just a couple of minutes, Joseph, if you want to finish your statement, and also pick it up with the connection with other human rights treaty body system we are in this session. And after this, we go into the general debate with Robert volunteered actually to be the moderator of this. So after Joseph, Robert, it's up to you. Joseph, go ahead.
Okay. Thank you very much. I was actually just concluding as I saw the disconnection on my screen. But I was just saying that the general comment actually gives us a lot of food for thought. That is to maybe develop further our discourse on land, consider further the holistic nature of land. And it's really, I think, very poignant what Joanna has said about the natural world and the natural connection between humans and land, not only indigenous peoples and their traditional connection to land, but actually the biological connection. This also takes us to the question of whether or not land as an element could be a human right. And we've had this discussion. The committee has not been very receptive to it. However, the committee was receptive to the argument in 2002 to recognize a human right to water, another essential and classic element, although it's not mentioned at all in the covenant. So this connection, this biological connection, is really quite important. Of course, CEDAW has been much more explicit, I think, when it comes to women's rights to land and what state obligations apply. And I just want to make one point, and that is that general recommendation number 34 is far more explicit, far more thorough, and far more helpful to states than anything coming out of the 2030 agenda. And this is a particular point in which we see that the human rights standards, of course, are prior, permanent, and binding, whereas the rather loose, voluntary, and temporary sustainable development goals, in particular 5.A in this case, are not at all as explicit or as instructive for states and others concerned with women's housing and land rights. Thanks.
Thank you very much, Joseph. Yes, Clarissa, I also promised you, so go ahead.
Thank you very much, and I'm honored to be here. I'm doing some work for UNCCD, and one of the things that I'm seeing emerge is this very big push for protected areas, and that's forests and other natural areas, to be expanded from their current 17% to 30%. And that's a minimum figure. There's even some conversations around 50% of land. And this is going to be needed in order to get to the carbon level required by the planet. So we are seeing a sort of a collision of goals here. Now, it would be very important to enrich that part of the guidance to be able to balance these goals. So issues around, let's say, the public right of acquisition of land for public purposes, and needs to be very carefully crafted in regard to that. And this shouldn't just be, one needs to imagine it as global public goods that are actually played out at local level. What is that going to mean? Yes, resettlement, but importantly, all the types of compensation that have to go as part of that. And this is not just about, rural in general. It's not just, it applies to smallholder farmers. It applies to indigenous areas. It applies to urban areas as they extend into agricultural areas. For instance, in the MENA region, we have about 7% agricultural land and massive city growth into that land. So it's also about food dependency. So to get that balance right is critically important for this document, because that is going to be the game for the next 10 years. Thank you.
Thank you, Clarissa. It's always a great pleasure to hear from you. For those who aren't aware, Clarissa is the founder of the Global Land Tool Network, and so very much somebody whose footsteps I am challenged to walk in. And it's a great pleasure to hear from you today. I see another request from the floor. Henry Thomas.
Yes, can you hear me?
Yes, we can hear you very well.
Okay, thank you. Just some points supporting what Christoph just explained. On the first one, I think particularly in relation with Article 1 and 15, possibly some reference from the UNRWA on how the land could be or should be exercised. It could refer something like alone or in association with others or as a community, because I think it is important to give character of a communal character into right to land. Of course, it should be clear and safeguarded. So I will suggest that some reference from UNRWA with the phrase alone or in association with others or as a community. So I think it could help the clarity of the article. On the second part, I think I have respect to the text present editions, and on the part of part one, respect. So Christoph also mentioned about the relation with food and seed, and I will reinforce this particular point, especially when seed by community and or by indigenous peoples, the seed freely saved, selected, exchanged, and or sold, as well as used and reused them. So I think this reference is so important to explain the link of land with indigenous peoples and with peasants and rural society. Just give me one more point is on. I agree with the first comment on a strong and clear reference to CEDAW general comment on rural women. I think it is also necessary. Thank you.
Thank you for those comments. I know we also have one in the chat from Amnesty, noting about the relationship to forced evictions and pointing out that forced evictions are never justified, and that they would recommend that this is made clear in this general comment rather than continuing with some ambiguities that have come forward from the past. I think that's always going to be a political issue to consider amongst the members of the committee. Also something that we're involved with on a regular basis. I guess that is something that we can take into consideration going forward. Any more requests for the floor or direct comments there? We will keep an eye out.
Yes.
Please,
yes.
Go ahead.
Turn the camera to you, maybe.
Here we go. I'm in the same room. Good afternoon, everyone. My name is Domenico Zippo. I'm a research fellow here at the Academy, and more specifically within the platform. And when it comes to my own research, we've been focusing very much on matters of implementation, on the use that the different outputs of the treaty body system are made at home. And in essence, when reading the draft, first of all, congratulations. It cannot be an easy task to put all these insightful elements within a 10,700 word limit document. And I'm aware that receiving all these comments can be surely hopefully helpful, but also yeah, not easy to include. So Approximately a year ago, we cooperated with the CEDAW committee on drafting their paper on cooperation between national human rights institutions and the committee. And within that initiative, we underwent a quick survey asking national human rights institutions on the way that they would see and the way that they would use the different outputs, whether they stemming from the communications, the general comments, the state reporting procedure, and the use of general comments by national human rights institutions was actually the faulty, let's say, parts of NHR engagement with the CEDAW committee. By reading the draft, I did not see any mention of the use that this document might have vis-a-vis NHRIs. I did see that there is a section on participation, consultation, and transparency. The CESCR is one of the few committees that has its own general comments on national human rights institutions' engagements, and it could be an idea also to leverage the activities of NHRIs in the country vis-a-vis the specific general comment to add, perhaps, if not a paragraph, but at least, or definitely a mention of the general comments on the NHRI engagements of the committee, but also perhaps ways, this would imply some research, of course, but ways that national human rights institutions can be of help within a specific, very important field. That's my comment. Thank you.
Thank you very much. I can see that Michael is asking for the floor. I will invite him to give any responses and comments that he would see fit, and I will probably do the same again when we take a few more comments as well. So Michael, over to you.
Yeah, thanks. And maybe it's good if I just respond to some of the remarks, and then we can continue with further remarks. Yeah, and I don't want to defend everything. I'm not in a defensive mode. I'm in a listening mode. Yeah, because we know there will be deficiencies in the text. You work on this, even if you work on this for a year or more, or 2 or 3 years with a lot of consultations. You have to bring all the things together. Yeah, and this is not always easy. Maybe just 2 or 3 remarks which I want to highlight is we have quoted 3 times the CEDAW General Comment 34. Just to elaborate this, yeah, we have it in paragraph 17 and also later in paragraph 40, 41. So at least this is already there. So it would be good if you could specifically look into that. In 17, we are also saying that access to security of tenure reduces women's exposure to violence, in part because women who have security in access to tenure can flee domestic violence more easily by seeking access to protection, but also by making women's household more secure, by enhancing women's self-confidence, self-esteem. Just to mention these, yeah, so we have taken up these issues from the GC 34 quite widely. So maybe you can be a bit more specific where else you would like to see this, yeah, and the same is also maybe related a bit to UNDROP. I think we have taken up all the content elements of Article 17. They are all in the text. You might be right, Christoph, that it would be easy maybe to make 1 or 2 more references to this, and in that sense quote UNDROP more. We can also do it maybe more at the beginning. I think we are waiting for your recommendations. I think there are opportunities, but I just want to flag that at least we were aware of all the content elements of Article 17, and they have been followed also in the text. Yeah, so that is important. I think it's also good when you say we should always quote peasants when we talk about vulnerable groups. These are things we can probably improve in the further drafting of the text. I would have one question concerning the treatment of protected areas, because this is not an easy discourse. I know also we had a lot of consultations that there's a lot of African voices who say protected areas is an old-moded concept. We need to integrate the people living and working there and think about a new concept of, let's say, protected areas. So we are eager to get good language if you have their proposals how to integrate these common discourses. Yeah, they are at least sometimes quite conflictive, and thinking about good language there, or how to harmonize these different perspectives. Let's say that in many protected areas, there are also people living there. How to combine these perspectives, I think, is a very challenging thing if you're looking for one or two sentences in that. Yeah. So maybe these are some first reactions to this. Yeah. I think thanks for your, let's say, highlights of things we should look into. I noted also maybe thinking about if urban perspective is missing, local governments, and maybe you can also write down some more, let's say, ideas you might have on the holistic nature of land. We have tried to extend this in the space we have at several areas by talking about the different functions land might also have for human beings in that context, but also for the environmental, let's say, integrity of soil, that land is not only something to use, it has its own environmental holistic perspective, but also cultural ones. So if you have specific proposals, particularly on these parts, it's always helpful for us. And if you have also specific references we might make, let us know. Yeah. Keep in mind that there are several interests in also all these references. We have been teased also to have substantive references to court decisions which are there from the African human rights system, the inter-American ones. So we've been quite searching for everything which you can find. We have quoted all the things the committee has done, regional human rights institutions has done, CEDAW general comments and so forth. But if you see anything you really think we should focus on, let us know. It is very helpful. We might always oversee something. Yeah. So maybe this is a first round of some reactions, not meant to be defensive. It's just saying where we have quoted some things you were asking for, but also asking for some specific, maybe further ideas on what you have said. Thanks.
Thank you, Michael. I think I would stress from my point of view again that the aim of the discussion today is the event today is really to open up the discussion and start highlighting the different issues. For my own organization and a number of our partners, we will look at the notes that come from this meeting and the points that have been highlighted to see what can be explored further and what sort of specific comments we can make. Because I imagine, as was suggested earlier, the more specific we can make those comments in textual terms and supported by an explanation, possibly the easier they might be to manage and that sort of thing. We will also try and encourage those participating today and others not present today to take up particular themes where strong elements are emerging, and look into those further so that we can develop the detail further. So really just to say, you know, we're not intending to try and get the specific detail of comments and conclusions here today. Let's see where it takes us and what avenues we should pursue in the next couple of months. I also think I would reiterate as well, I'm very reassured to hear that the overall reception is very positive and people are very supportive of this initiative. And we are in that inevitable trend when you ask people to comment, you're always picking on what you want to change, because it seems almost redundant to say what you do like. And that, certainly from my own point of view, I like 99% of what I'm looking at, and my element of requests for changes are relatively minor. Clarissa, I can see you. I think I've got you as the one asking for the floor at the moment.
Yeah, just very, very quickly to say that there is definitely I'm mixing a lot now with scientists, and there's definitely a complete change and an understanding that protected areas are occupied. So that becomes also something that I can contribute to as we go down the way, because there's now science emerging around that issue. However, the science is also saying that while that is not sufficient on its own, that there will be a lot of land use change and change in human settlement patterns, according to what I'm reading. And so yes, that's part of the answer, but there's also another part that has to be addressed. So yes, I'm really happy to engage. Thanks for giving me the floor. I'm sorry, I have to leave.
Thanks, Clarissa. I think yeah, Christoph, please go ahead.
Thank you very much. Thank you very much, Michael, for the very positive response. It's great to see that it's open. I just want to add that the Article 5 of the Declaration on the Rights of Peasants is on the right to natural resources. That of course include land, and it's quite important because it says in which conditions these resources can be exploited, and there is a need for human rights impact assessment. There is a need for consultation in good faith. There is a need for benefit sharing. So it's all there. And for your information, when the declaration was drafted, we had free prior informed consent in the declaration. Then states said, no, we cannot accept that for peasants. It was deleted, and there was nothing to replace that. But we discussed with the states, and then they accepted to include Article 2.3 about consultation in good faith, and to put it again in Article 5. When there is exploitation of natural resources, there should be consultation in good faith with peasants and other people working in those areas. The consultation in good faith and Article 2.3 are taken word by word from the guidelines adopted in 2012 at the Committee on World Food Security, where, as you know, there was a distinction between the free prior informed consent of indigenous peoples and the consultation in good faith for other communities, which of course include peasants. So that it was a compromise, again accepted by states, and so that's why we think. But again, we will submit contributions by writing. But we think that Article 5 also is relevant for this general comment. Thank you very much.
You're welcome. Thank you. Yeah, Camelia, please.
Thank you. No, I was also mindful to reply to Michael. He said it, I think, 2 or 3 times, and also Felix was mumbling that there are 3,000 more words. Or what did you say?
300.
300 too many.
Yeah. So it's just, Michael, I was thinking about this probably more in my lawyer's hat, not that much in my Geneva Cities Hub hat. I was struggling with the introduction, which is probably quite long, but also it's having some very interesting stuff in there. Just you speak here again about peasants, about financialization of housing markets, which is, as I think, as universe per se, and many other findings. So I was wondering whether you cannot shorten and transform the introduction either in footnotes or probably in some conclusions, because you don't have a part of a conclusions, and shorten this part, because I don't know where the introduction leads you. It opens up other issues, other topics, which you cannot exactly find under the same or in a more developed level in the main body of the text. So I think that there is area of improvement and shortening of the introduction. The other thing I'm struggling from the beginning, but I didn't speak because I thought somebody else will do it, but probably in the comment we will receive it, is the part called armed conflicts and post-conflict situations. It tackles many things, IDPs. Actually, to be honest, I don't know what is this about. Is it about IDPs? Is it about conflict, post-conflicts? I understand you have to be short, but I'm afraid you cannot in 4 paragraphs resume probably tons of thousands of stuff which the other community, the humanitarian people have written about, you know, land and land in the conflict, in protracted conflict, etc. Again, I'm not an expert, but you have tons of writings by the experts also, guys sitting in the same villa like us. So I wonder, and sorry, I'm quite operational here, but we are at the beginning of the discussion, whether you need at all to enter into sort of an endless debate, which will be armed conflict and post-conflict situations, whether you don't want to shorten this into probably a general point referring to the work of the ICRC and others, because as you can imagine, there is plenty of stuff there. And probably this is a comment also for the other parts of these specific topics, which seems all of them really big issues, but completely rushed. I don't know, just an open question, as lawyer, whether it is helpful to mention, I don't know, corruption in just 2 paragraphs, or climate change, whether it is not more helpful probably to recognize that there are other issues which could have found their place in this general comment, but you concentrate on what is in the main body of it, and just don't go in a short terms in big topics, because they sort of we are not satisfied why it is so short, but then we understand that it cannot be bigger. So I just to conclude, I wonder whether there is a little bit more work to fine-tune these 2 parts, the introduction and the specific topics, and hopefully to shorten them. Thank you.
Thank you very much. I note the comment by the International Land Coalition that they will also be starting a consultation process quite soon amongst their membership, and obviously encourage everybody to work through that avenue as well. I apologize if I'm mispronouncing. Is it Alev asking for the floor?
Alev, yes.
Okay, please go ahead.
Wait 1 second. Yes. So the question is simple. UN ROP, it only covers peasants that are not paid. So today there's a lot of people working in bad conditions that are paid, and I believe that it should be covered in UN ROP. What do you say? Can you hear me?
Yes, we can hear you.
Oh.
Okay.
That's all my question.
All right, no problem. Anything further? Okay. Before I come back to Michael again to respond on those quick couple of things, there's one I would add in here as well. That I'm reflecting a little bit on section 3C and the national obligations and the framework under respect, protect, fulfill. In a general sense, I'm thinking it's perhaps out of necessity, I could accept, but it's a relatively conventional framework of legislation and regulatory roles that are being looked at. And I'm wondering if there might be space to introduce the argument that the nature of the public right to regulate land use has expanded a lot in recent years, and it's changed in nature. And you could argue that it's closer now in some ways to a sort of co-management concept. For example, urban planning is, it's now almost an accepted principle that urban planning should be participatory in some form. It's not purely an abstract state function. That extends to a certain extent to rural areas as well. So where that has come in some countries is to actually entrench some of that consultation and the right for it, even in some cases, to be actionable, for that to be entrenched into policy and law. Similarly, to impose more good faith and community-oriented obligations. on landowners and land users. Usually the cases I've seen have been more what perhaps you've picked up as being commercial users of land, so large-scale landowners. But I think also through planning processes and sometimes through local government actions, it also comes into the ways in which smaller scale landowners are using their land. For example, a lot of the arguments that are coming up at the moment around Airbnb and temporary housing and the impacts that has in certain areas is in effect expanding the scope and the concept of the public right to regulate. So that's certainly something we would look at. Okay, let me go to Michael just quickly, and then I can see Henry's hand is up, and I will come to him immediately after Michael.
Okay, just some few reactions to what you have said. We can reflect where maybe agricultural workers can be particularly mentioned. That is something we can do. All your recommendations, Camelia, to shorten introduction and the specific issues. I hear this, and we might have to consider this if we get new things to take up. But keep in mind that it's also a committee which has certain interests. Yeah, and drafting together with the Colombian general comment on land and not talking about land conflicts is it's a no-go. It will not work. Yeah, just to let you know, there are interests also which deliberately needs to be reflected. It's more better than to see are there things still missing in that context. Yeah, but it would be impossible to have not a section on armed conflict and post-conflict regulations in the text, given our structure of the committee, just to let you know. So there are some certain arguments, and we can think about taking up maybe the one or the other specific issues, or maybe drop one or the other. That's further to the, let's say, editing team or the drafting team, but also later then in the committee. And there are also some committee members which are particularly interested in certain parts of the introduction and so forth. So this is always like the text goes, yeah. But I take note of this, and it's very interesting if you make proposals in this aspect. It might help us in the further argumentation. But I think armed conflict and post-conflict situations are extremely relevant for so many countries, yeah, and so complicated that it needs to be discussed, that you need maybe also forms of negotiations which needs to take on board the different layers of interest which are there for the same plot of land historically, and then changed over time just in order to find a way out. I think it's interesting to hear about new maybe co-managing concepts and planning. We have already taken up rural planning, regional planning, spatial planning already as an important component, because they are often forgotten how important they are. And I think, Robert, it's very good that you pinpoint to this. Let's have a look at this. On the other hand, we know that in so many rural situation or urban situation, conventional governance is still needed in order to deal with 90% of all the problems which are happening, yeah, where people are overseen. So we have to have a good mixture, yeah, where this governance is reinforced by a way that it becomes working for vulnerable and poor people as well, yeah. But at the same time, maybe to open doors for these new forms of, let's say, management concepts. I think it's very interesting to consider this. Yeah. So you can easily see, it's very interesting for us, this discussion Joanna has mentioned. We can also mention CEDAW 34 in paragraph 16. That is a good proposal. So there is already, I see a lot of things which we can take on board when you dive into the details. So thanks really a lot. Yeah, also Christoph referring to Article 5 of that UNDROP text is maybe a good opportunity also to mention UNDROP specifically in these parts. So I take already note a lot of things. Thanks for this, and we are looking very much forward to getting maybe some responses in writing. Yeah, particularly if you take on board when you make lengthy proposals what we should delete, because this is really the biggest pain in the process. Yeah, that you have this limitation to the length. Yeah. Thanks.
A good management principle always one in, one out. Otherwise, you end up with indefinite responsibilities and obligations. Henry, I had said that I would come immediately back to you.
Thank you for the time. I just want to respond on 2 points. Just to respond very quickly. One on agriculture worker. I think any proposal for formulation, I think it should be welcome. Try to to put a reality of rural life, at present or in the past, or the legacy of the past. I think what is difficult with the agriculture workers, as I understand during negotiations back in 5 to 6 years ago, is the element of migration. That is difficult. But as long as we pinpoint to the reality of land and governance and how this right exercise within the nature of state obligation, then it is clear, I think. And also, as Mikhail Vintfore explained, trying to mix different standards and trying to also enable a certain standard for these protections. On the second point, is very quick also on this. I think I still see some room for improvement on the part of respect, because I see respect is also the part which we relate from one standard to the other, or one standard to many others. So at present, I think I see the clarity. Thank you for the drafting, and I still trying to to give input whenever it is relevant. Thank you.
Thank you. Any other requests for the floor or comments that we should put forward? Balloon, please.
Yeah, hello everyone. I'm very sorry I missed most of it. I was in a class. I just wanted to make one point. Hi, Mikhail. Hi, Camelia, Felix, everyone. There's been this vexed issue of whether the committee should recognize land as a human right. And I mean, the general comment is sort of skirting around that important topic. And since it's been recognized as a right in the Declaration on Peasants, on indigenous, in the general comment from CEDAW, I'm just wondering if, even though the committee doesn't have to take a stand on that, but at least if there were 1 or 2 more paragraphs that that sort of touched on that issue and left it open, and in a sense not close the door, because I think that's a huge gap in international law, and it would be tremendous if, as the committee did for the right to water, if there was some advance in the draft general comment on moving in that direction. Thanks very much.
Thank you very much for that. Anything further, or shall we start moving towards closing? Well, I will keep an eye out for any final comments that come in, but start wrapping up. From my point of view, as Habitat, and also in our role in supporting the Global Landfill Network, there are a couple of things that immediately come to mind. In holding this meeting, we have already proposed to have a follow-up meeting, probably early July, when people have really had a chance to digest the detail properly, when we have some specific proposals for comments that could be submitted, and we can look at how we might wish to put those forward collectively or individually or in any other way. But the idea would be to have a more focused and more fully prepared discussion at that stage. I think what's also clear to me is that there are several sort of themes already emerging around areas that people are taking a strong interest in. I think, you know, where people would like to, and if they are willing to, please do forward those also by email. We will look at the recording of this meeting and the notes that we've taken to look at what we can pull out of that. But maybe what we can start doing is circulating that something says, here are what we believe are some of the key issues and themes that were raised. These are the different avenues that those could take us down. Do we need to have further discussions? Is it clear? That sort of thing. And that would give us a way forward over the next month or two to see how we can break it down and analyze it a little bit better. And recognizing, you know, I would assume if it's anything like other processes I've been involved with, and I think Michael is hinting at this very strongly, the more focused and the more practical we can make the comments that we put forward, the easier it will be for the committee to review those and consider them. And then we may have a better chance of things coming on board. So I think from our side, we would look at some specific notes and comments that we would circulate. We will look for a way, because we don't really have a mailing list for this, but we will make a
publish on our website.
Yeah.
So open questions.
Something like that to be the next stage in the discussion. We will state very clearly that we're pushing towards finalizing a set of comments that could be submitted in July. That's obviously without exclusion to what others are doing. We would also encourage everybody to share information about the general comment in this meeting as widely as possible. If we can link with other consultation processes like that proposed by ILC and others, so much the better, because I think the more we all interact, the stronger on this. So these are my initial thoughts on what the way forward looks like in the short term. I think there's going to be a whole bigger discussion around what the long-term future is, because one of the issues with some of the other general comments is how do we push implementation forward? How do we get the recognition? How do we use them? And I think that's also something we need to keep in reserve as a discussion that we will have going forward. I would welcome, I know Michael has to leave very sharply. I would welcome any observations that he might have on issues of the way forward, but also for anybody else, whether of the partners in hosting this meeting or anyone else, please do feel free to comment, suggest, reorient, or anything else. Michael, would you like to make any immediate observations on the way forward?
May I ask a question?
Yeah, Joseph.
This is to you, Mikhail. I'm noticing that in the committee of 18 members, 10 of them are fresh, completely new. How does that complicate or otherwise mitigate your process? Is that going to be, will you have to prolong the process? Or is there anything that we should know about the composition of the committee that we could maybe help to support in your process?
Yeah, thanks a lot. And maybe I start with this and then go to the further process. Well, we had an intensive discussion, a first reading, as we call it in the committee, in our autumn session last year, or September, October, where we discussed already most of the concepts and the content, the structure, and also some of the things, if we should talk about the right to land, or if it is better land and covenant rights. And there was a clear understanding that land is important for the realization of several rights, and it's not like with water, which is part of an adequate standard of living, food, clothing, housing, and it has been already discussed in a general comment before the UN General Assembly was diving into this. So the standards for interpretation were set by the committee. It's a bit different, at least in the view of many committee members. So we can go back to this, and I think Christoph made already some very good proposals how to quote the right to land from other sources. And I think Milun said the same, in order to keep the door open So we have to see, and we'll further dive into this discussion. But this is a considerable, thorough discussion which we had in autumn. And with the new committee members, which we now have since this year, I think what we did in the early session, which we had this year already, even if it was online, we took a lot of time to explaining the process and the context, how far we are. So we went through the general comment in explaining what type of process is behind this document, why we have a certain structure and elements. So we explained the whole text again to them. So I think the most important step is onboarding of everybody in the committee, because we need at the end also the consent of all members. Yeah, so that requires also a lot of internal discussions, but we tried to do our best, and I think it was a very rich and useful discussion which we already had with the new members. And with each new member, you get also new perspectives in such a committee, which is good. But I think we had a very good onboarding discussion on the general comment on land. Yeah, and now we will make a good documentary of all the comments we are going to receive. So we want to prepare them all for the committee itself, so that they get an idea who has responded in which way, what are the topics, what are the main aspects which has been raised. We will get comments from states, from NGOs, we will get comments from UN agencies, we will get comments from academia. So we will systematize this as we do it normally also with general comments. And then we have to explain as rapporteurs which of these comments we have taken up in which way, and why we maybe don't have taken up others. So this is then the process in the committee, yeah, like it works, yeah. And so it's a lot of reasoning behind that which is needed, and I think that is also a very positive way of getting the consent of a committee. Yeah, it's really how to say. You need to have these discussions ongoing. You have to have enough time for this deliberative, let's say, mood of discussion. Yeah? And I'm quite optimistic that we can achieve a consensus on that. And any specific recommendation from your side is really nice. Yeah, I know that the rules for making comments says you can send in up to 5 pages or whatever. You can also make 3 comments and track changes, which can also be helpful for us. Yeah? So you don't have to elaborate large text. If we get 500 times 5 pages, it's also something to read. If we get maybe some specific proposals for paragraphs, it can also be helpful. Yeah, so do both. Yeah, don't feel limited, but it will be very helpful. And as I said, we will dive into each of the comments we are going to receive.
Well, then from me, just really to say an enormous thank you to Michael. I think without your participation today, we would have had a much, much poorer discussion. And I think the insights into the development of the draft, the description that you provided and the responses to questions have been wonderful. So thank you very much for taking the time to do that. I think with the last couple of minutes, I'd better hand over really to Felix and Camelia as my co-hosts here. But thank you again to the Geneva Human Rights Platform and the Academy for making this happen, and for everybody for joining in the discussion. We look forward to taking this forward.
Thank you, Robert. Up to you. You'll be the porte-parole.
Well, so also to say from our side, from the Geneva Human Rights Platform, thank you very much. Thank you, Michael. Thank you to all those who have intervened and taken part in the discussion. I think we also had an interesting side discussion on the scope of UNDROP, which I think is sorted out by now. When we close the chat, we have done that. So actually, no, it's not a joke. I think it's really good to see that we have that possibility of using such a meeting. You know, always we say those online meetings, we cannot really have the coffee break, but here we can really go ahead and also clarify additional and related questions with the experts that are in the room, and we see that we are really all in that room together, and I think it's great to see that also in a virtual discussion. Let me thank also the interpreters, Robert, Wendy, Juan, and Camilla, as well as my colleague Yasmin here in the room, who facilitated this meeting. Thank you all for your contributions, and indeed, On the website of the Geneva Human Rights Platform and also in our newsletter, you'll find information on that meeting, including the link to the latest, the advanced edited version of this general comment. So also with the necessary explanation and the link to our HCHR website where and how to give the input. So we'll have that on our websites, including on the Geneva Cities Hub, also to reach other audiences. So we really team up between all of us. And we're very much looking forward to hosting you again in July for the follow-up discussion to this meeting today, again with the same group of co-organizers. And I hope all of you again also online. Camelia?
No, thank you. Thank you to all, and absolutely thank the interpreter, the whole team of the Geneva Academy, UN Habitat, and Michael to bear with us. And looking forward to the next step. As we said, publications on our respective websites and meeting early July.
Thank you very much. And to all of you, have a good day, afternoon, morning, wherever we are. And thanks again for having come to that meeting. And as mentioned, if you want to share it later also with other people in your networks, you'll find the recording on our websites. So thank you all.
Goodbye.